Alright, Sam. This is my little lecture slash helpful video. I hope it's helpful for you. I wanted to go over the objection that you got on Sunday for the coaches scrimmage. By the way, if you hear cars going by, I'm outside. You know I'm incorrigible. Smoking a cigar. Anyway, um, I wanted to go over the objection you got on Sunday against Tim during the coaches scrimmage. In particular, you know, what my train of thought was as the judge, and how I think you could have responded better, so that we're clearer on exactly what we're asking you to do as coaches, and hopefully you learn something. Um, Let me know if this is helpful. Um, I was going to do sort of just a audio file and just sort of talk through it, but then I realized when I when it became very clear that I was talking in circles, that it would have been a lot more helpful for me to actually play you the video instead of, just talking loosely about it or having you watch it and then coming back to you later. Let's just do the two things contemporaneously. Let's look at the video together, and I'll pause at certain points to explain to you what I'm thinking or explain to you what I'm saying in the video, insofar as I think that I say something or that Tim says something that requires some clarification. Alright? So, let's do it.
Was about, and she's talking about the content of a phone call.
Your Honor,
We're not even to the statement at this point. We're talking about the content.
I'm going to back up a little bit so we get the full extent of the objection.
Feel that it's objectionable, you agree to re-object. So let's go through that first.
Okay, so this is after I've asked you to proffer.
Yes, Your Honor.
This is after I asked you to proffer what your statement was going to be, pretending to be a judge who didn't know where you were going on cross and didn't know your case. Okay.
You got a phone call about things you needed to do in preparation for Ms. Kosak and Elias on set, right?
Yes, actually, hearsay, Your Honor. That's a hearsay statement saying what the phone call was about, and she's talking about the content of a phone call.
Your Honor, if I may
We're not even
respond.
to the statement at this point. We're talking about the content of a phone call from someone who's not a party owner.
Okay, in response.
Once again, Your Honor, no statement has been elicited. Now, given the context of the phone call...
Alright, let's stop there. So at this point, I think it's very helpful to go over what hearsay is, because your first response to his objection to hearsay, or under the hearsay rule, was that no statement was elicited. Well, what is a statement exactly? I think a lot of times, what we tell people, especially people who start off on the B team, I was one of those people, so I kind of feel you on that one, so to speak. One of the things that we tell you guys as you start out is that, well, a hearsay statement's usually a quote, okay? Which is, 9 times out of 10 true, right? A statement is a loosely thought of, or colloquially speaking, a quote. But the hearsay rule is a little more specific than that. Obviously, Rule 801 defines hearsay, and it has 4 main subparts, A, B, C, and D. But for the purposes of this, I think A, B, and C should be our focal point here. Okay, so a statement, as defined under 801A, is a person's oral assertion, written assertion, or nonverbal conduct if it's intended as an assertion. So, in other words, it's anything that has the tendency to assert a fact or impose a fact into the record, right? So, in other words, it could be a quote, right? It could just be something relatively simple. Let's see here. A hearsay statement could be something like the quote. Let's say the quote is, "I like ice cream." Right? So if the quote is, "I like ice cream," there's an assertion of fact there, right? The assertion is, well, I or whoever the person speaking likes ice cream, or something to that effect, right? So 801B tells us that the declarant is the person who makes the statement. So if I said that, which sounds like something I would say because I'm fat, um, I'm the declarant in that instance. All right, I know this might seem a little condescending, but I think all of this is kind of important to go through in some detail. All right, so this is a direct quote, and I think a lot of times we get into the trap of thinking of hearsay solely in this way, that it has to be a direct quotation, but it doesn't have to. What if somebody testifies in court something like this? What if someone says, Jabari told me that he likes ice cream? That statement isn't necessarily a quote, right? It's not me offering a word for word recitation of what Jabari said, but it has the tendency of doing what? It has the tendency of asserting a fact. And that's all a statement has to do for the purposes of hearsay. It doesn't have to be a line by line quotation. It just has to be essentially a sentence or the conveyance of a sentiment or a claim made by someone that was out of court, um, that claims a fact or makes a particular claim for something, right? So let me make sure this doesn't do what I think it'll do. And it did. Okay. All right. So this isn't a direct quotation, but that could still be hearsay. So simply saying no statement has been elicited doesn't necessarily get you out of the hearsay, because a statement can still be elicited even though there's no direct quote. All a statement has to be is just a mention, an allusion to an out-of-court assertion, a fact that's made. And like the rule says, it could be oral or written, or it could even be nonverbal. So that right there kind of gives us a hint. If a statement could be nonverbal, then logically speaking, it follows that it's not necessary for the purpose of this rule that the hearsay statement or the alleged hearsay statement is a quotation. It could just be any mention of a claim made outside of court asserting a fact, right? Again, go back to the example one more time. Let's see if it'll cooperate. Jabari told me that he likes ice cream. Me relaying a sentiment, or a witness relaying a sentiment of what I said out of court. Essentially the gist that I like ice cream, versus the witness offering a word-for-word recitation of what was said. Okay? Both could be hearsay. Let's go back.
It's not going to show the truth of the matter asserted. And if I may proffer, once again, it'll show the actions that this witness took or didn't take in preparation for Ms. Kosak to be on set, and is not being offered for individual specific instances and content of the phone call.
Your petition about X, right?
Yes, Your Honor.
All right, sorry.
Your Honor,
There'll probably be a weird jump in the video. I apologize for that. I hit the wrong button. But anyway, all right. So let's listen to that response, or let's think about that response. All right. So you said, let's go back to it, just to be
If I may
clear.
proffer, once again, it'll show the actions that this witness took or didn't take in preparation for Ms. Kosak to be on set, and is not being offered for individual specific.
All right. So in other words, you're offering this for the subsequent action, right? So what do we mean when we say that we're offering something for subsequent action? Well, let's go back to the hearsay definition, right? So we know what a statement is. We know the declarant, the person who makes a statement. The hearsay definition really comes to the fore in the C part of the rule here. Okay. The declarant, hearsay means that the declarant has made a statement while testifying at the current trial, and the party offers into evidence that statement to prove the truth of the matter asserted in the statement. And if I could bold a website or a bold font in a website, I would, because this is the most important part of that. Hearsay is an out-of-court statement being offered for the truth of the matter asserted in the statement. So when we say something goes to subsequent action, we're saying we're offering whatever that statement was that was out of court, that was made out of court, not to prove that the content in the statement was true, but that but that whatever. It could be any other purpose other than proving the truth of the matter asserted in the statement. So what do we mean by that? Let's go back to our examples with ice cream, because we're fat. Or I'm fat. You're not fat, I am. I like ice cream. If we offered this out-of-court statement for the truth of the matter asserted, we'd be essentially saying, here's a statement that Jabari made out of court saying that he likes ice cream, and we're offering that statement into evidence to prove that he does indeed like ice cream. That's offering a statement for the truth of the matter that it asserts, right? If we're going to show subsequent action, it has to have some sort of tendency to explain, well, the subsequent action that the listener took upon hearing the statement, or that someone else took upon hearing the statement, right? It has to have, you don't have to prove a causal connection as a way to get over the hearsay bar, but in a way, there has to be some sort of logical connection that could be made. You don't have to prove conclusively that it was made, that it does exist. You just have to prove it, or rather, it has to be apparent that it could be the case that a particular statement led to a particular action taken by a listener, right? Let's see. All right, so just to make that point clear, let's do this. Let's take the statement, go to bed. Now, let's say if this was offered into evidence for some reason. Assuming that this statement even has truth value, and it's hard to say that it does, but assuming it does, we wouldn't be offering this statement to prove that indeed go to bed is true. If we're offering it for subsequent action, we're using it to explain or to give a reason why the listener, whoever it was, went to bed. Subsequent action, right? Stuff you know, but again, I think it's important foundation here. So your first offer was subsequent action. Now, I think where the whole sort of incident went awry was the meat of Tim's objection then changed. And obviously, as you know, the most important part of responding to objections, and the hardest part, even harder than actually knowing the rules and being able to understand them and argue them, is knowing exactly what the other person is claiming, right? If you can't do that, then you don't know what to say, and you're going to sound as if you're offering a bunch of non sequiturs. And if you sound like you're offering a bunch of non sequiturs, then the judge is going to be less than pleased and less likely to rule in your favor. So, let's try to figure out exactly what Tim is saying here. We'll do that together. Let's see. Oh, I just screwed up. Let's see here. Alright, fixed it. Here we go.
Specific instances and content of the phone call.
Your particular.
Well, sorry, I'm a little obsessive. I want to go back a little bit. I want to pay attention to a particular part of what you just said here in the video.
I may proffer, once again, it'll show the actions that this witness took or didn't take in preparation for Ms. Kosak to be on set and is not being offered for individual specific instances and content of the phone call.
Okay, here we go. Truth value. Not offering the statements to show the individual content of what's being said. Here's the thing. Whenever you offer a statement, you're always offering it for its content, no matter what. Right? Think about the logical conclusion of what you just said. So, let's say if you are offering a statement without trying to show its content, oh sorry, I can't spell, then why use it at all? Okay? Why use it at all? I'm going to make that one big and bolded, because that's an important question, right? Whenever you offer a statement, you're always offering it. I'm sorry. There we go. Whenever you're offering a statement, you're always trying to get its content out. So to say that you're not trying to offer it for specific instances of content in the conversation is wrong. You're always doing that. But there's an important distinction to be made between offering a statement's content and offering its truth value. Okay? I'm going to make this next point even bigger. Content is not the same as truth value. And this is why this sort of tete-a-tete here was probably a little longer than you would have liked. Probably longer than I would have liked, because it did take a while. But you have to make that clear. But because you moved the goalpost, and your interpretation of the hearsay rule was that you can't offer a statement to show its content, essentially, which is what you imply by saying, Your Honor, it's not hearsay because we're not offering it to show the content of the statement, then you make it harder on yourself unduly, and I now have to consider your logic and your rationale on those grounds. And you've essentially made it harder on yourself. You moved the goalpost on yourself, right? And that's what any judge is going to do. If you impose onto yourself a higher standard, a lot of judges, not all of them, but a lot of them will take you at your word. And if you're wrong, they'll go against you. In this case, they'll sustain Tim's objection. They won't say, okay, well, she says that statements aren't offered for their content, but that's wrong. I'm going to rule the way I think is best anyway, despite her argument. They're going to rule a lot of times based on your argument. And you put yourself into a corner here when you say that. Right? And now watch what Tim does in response.
Her particular question was, the conversation was about X, right?
Yes, Your Honor.
Your Honor, may I respond to that? Counsel can't just characterize hearsay and then admit it without, circumvent the hearsay rules. Counsel wants it to be on the record what this phone call is about, because she wants to use that against the plaintiff in this case to say that specific information was ignored. That's hearsay, and it's not contained under any exception to the rule.
All right, see what he did there? So he took your claim, essentially, that you can't offer the statement for its specific instances of content and said, well, Your Honor, that's exactly what he's doing, or what you're doing. That's exactly what she's doing when she's offering the statement, even though you said that you aren't. And He's contesting that because you are offering the statement for its content, that it's hearsay. Now you have to, again, in your next response, you have to bring this up. Content is not the same as truth value, and you have to explain that distinction. But you don't quite do it here. And I kind of try to help you out here by, going on one of my legendary soliloquies and probably talking a little too much here. But try to listen to what I'm saying here in the video and not just in my commentary now.
The specific question was, this conversation was about the safety, right?
No, Your Honor. This question was about a phone call that this witness received about preparation on set. Now, no specific statement has been elicited as to what that preparation needed to be, what this witness needed to do, or rather that there was a conversation about things that needed to be done.
Well, let me kind of explain to you what I'm thinking. So he's essentially saying that in order for him to be able to characterize the conversation at all, he has to be relying on out-of-court statements, right? Because this conversation took place out of court, right?
That's correct.
So this witness, in order to be able to characterize that conversation, would have to rely on the content of that conversation.
Not necessarily, Your Honor. But this is
There you go. See? I'm trying to explain to you what his objection is, essentially. It's that because you're trying to characterize an out-of-court conversation, you are relying on its content. And I asked you up front, I said, are you relying on the content of an out-of-court conversation and characterizing that conversation in the form of your question? And you said, no, we're not. Why did you say no, we're not? Well, I can't speculate, but I think it's because, not to beat a dead horse here, you forgot this distinction and you moved the goalpost on yourself. You stated from the jump that you essentially aren't allowed to offer the content of a statement at all, that the rule bars you from doing that. And because you believed or you asserted, at the very least, that the rule disallowed you from doing that, you shied away from it instead of embracing that you are offering it for the content, but that the content was not the same as truth value. And because it wasn't going to the truth value of the statement, or whatever the particulars of the conversation were, it's not hearsay. But you didn't say that. And once more, because you said that you weren't offering a statement for its content, you kind of made yourself sound a little asinine. Why? Because if you're not going to use a statement for its content, why would you use it at all? Of course, when you characterize a conversation, just common sense, think logically about it. Common sense tells you that what? That if you're characterizing a conversation, you need the content of that conversation to be able to base an opinion or base any form of summary. So just something to keep in mind. All right?
it's going to show is that there is context of the conversation and not explicitly what was stated. And so, as those statements are being listed at this time, it's going to framework, if you will.
You keep saying those things. Yeah, there are no quotes, but what he's essentially saying is for you to characterize a conversation at all, for you to try to get this witness to characterize the conversation at all, requires him to take the content of an out-of-court conversation and essentially rely on.
So here I am again, explaining to you what the objection is, which is, yeah, regardless of whether or not they're quotes, because remember, we don't need quotes. You are characterizing an out-of-court conversation, and in order for you to do that, you have to rely on the content of that out-of-court, that out-of-court conversation. Thus, the question becomes, in this sort of objection battle, is are characterizations of out of court statements. Hearsay. Right? So you got to respond on that. That's your new question. Okay? Let's get the new video up. Oh, this one's taking a little longer. Give me a second.
Hearsay on the
Oh,
record.
there it is.
So, so can he essentially characterize the conversation in that way, relying on out-of-court statements?
Yes, Your Honor, because it's going to the subsequent action or the effect that it then had on him as the listener.
Okay, what effect was that?
For him to write down and record or not record in this case what he needed to do before the performance.
Okay, so this conversation about safety is going to show his particular writing it down. So
How he acted in preparation for Mrs. Kosak and Elias to come on set.
what do you have
Okay.
in response to that?
Again,
Well, Your Honor,
again, you've offered the Again, you offered the subsequent action response, which is fine, but as Tim's going to tell you, try to claim you essentially need to lay the foundation that, as we said before when we talked about the example with the go-to-bed statement, you have to prove some sort of logical connection between the statement that you're offering and the subsequent action.
she needs to lay if we're going to go the subsequent action route, then we need to lay foundation for how the specific content at issue caused a subsequent action. Here, I think all she's really trying to say is he received a call and didn't write anything down.
Don't you love that person named buffering? I'm sorry. This is kind of a pain for you to sit through. I'm going to try to get it to speed up. Alright, let's try it now.
To then inject into that that the call was pertaining to safety information is still hearsay. And the fact that he did or didn't write something down after the fact doesn't get around the fact that the call is still hearsay and the content is hearsay.
Alright, let's think about exactly what he just said. Alright, so you've already offered your subsequent action response, but he's saying regardless of the subsequent action, even if you establish the logical connection, which you still have to do, he's saying, well then why is it even necessary to say what the statement is at all? And that makes it especially agreeable to the court or to a judge who's, again, ruling solely based on your arguments and not what the rules actually say a lot of the times, at least in my trial. That makes it easy when you've already said that you're not offering the statements for its content. Again, you have to point out here that content is not the same as truth value. And more specifically, he's saying also that what? He's saying that to, as he put it, inject what the conversation was about is hearsay. Right? And now here's where we really want to split hairs logically here. But this is still a worthwhile distinction, so maybe I shouldn't even use the phrase split hairs. It's just a really fine distinction. The characterization of the out-of-court statement might seem to be hearsay because you are offering the characterization as a true statement. In other words, you are trying to get the witness to agree to the claim that the conversation was about safety. You want that to be true, right? But in order for you to get there and to prove that the conversation was about safety, you need its content. But that does not necessarily mean that the truth of the matter or that the content goes to the truth of the matter, because the content is not the same as the truth value. All right? Let's go back to our ice cream example to make this a little clearer, and then I'm going to try to let you go. Okay? Give me 1 second. Alright, so let's take the example of Jabari likes ice cream. Right? Or I like ice cream. Okay? Let's say while in court, let's do it this way. Let's say while in court, someone says Jabari and so-and-so, whoever was talking with Jabari, were discussing ice cream. Okay? So that's a characterization, right, of the out-of-court statement. Essentially exactly what you were doing. Our characterizations of out-of-court statements hearsay. Or as Tim put it, let me put the extra is there, sorry. As Tim put it, is about. As Tim put it, injecting what the conversation was about, relying on the content of the out-of-court statement. That's not hearsay. Characterizations on the out-of-court statement do rely on the content. But remember, content is not the same as the truth value. So in a sense, here's where that distinction comes in. Your opinion that the conversation was about safety, you want that to be true. And this is where the confusion came in for me as a judge trying to rule on this fairly. And that's where I kind of got hung up, and I guess it's my fault. But in a real round, the burden's on you to prove it. While, as Tim said, you're trying to show that the conversation was about safety, and you want that to be true. But just because you want the characterization to be true doesn't mean that the underlying content of the statement goes to the truth of the matter. Why? Bam, right there. As I said at the very beginning, see how it all comes full circle? I try not to waste your time. That's why I went kind of pedantically through all of this. Right there. Because hearsay is an out-of-court statement off for the truth of the matter asserted in the statement. So a characterization, while you do want it to be true, you do want it to be the case that the conversation was about safety. And for you to say that, you do rely on the content of those out-of-court statements. That doesn't mean that your summation about those out-of-court statements is therefore hearsay, because the content that you're using that becomes the basis of your characterization are not necessarily statements going to prove the truth of the matter within themselves. Within themselves. Let me make this as clear as I can with going back to the Jabari and ice cream example. Jabari says, I like ice cream. You say, or someone says in court, Jabari and the person to whom Jabari was speaking were discussing ice cream. You're characterizing the out-of-court statement in the same way that you do during the Clark cross about the phone call with safety, right? You're characterizing the out-of-court statement. In order for you to characterize the out-of-court statement, you are relying on the out-of-court content. But you're not using its truth value, nor are you using the truth of the matter asserted in the statement. What is the truth of the matter asserted in this statement? I like ice cream. What are you doing here? All you're doing here is saying, well, Jabari was talking about ice cream, but it has nothing to do with the truth value of the underlying statement from which we have deduced the conversation's topic, right? And these are the kind of fine-grained distinctions that are critical for good objection responses. And I realize it's a lot, but it comes with practice, and it really comes with thinking through these rules logically. You want to think about the purpose of the rule. I want to write down some rules of thumb here. So from here on out, I want you to think of the purpose of the rule. And then I want you to use Kantian's rule. Kantian's rule. That's how you know I'm tired. It's been a kind of a long day. Universalize the maxim. In Kantian ethics, you universalize the maxim in order to prove its logical validity and its universality. If the rule can be applied on a universal scale without collapsing on itself or contradicting itself through its multiple iterations, then you know the rule is true. Or at least you know the rule is valid in an ethical sense. That's the Kantian, or a very crude reduction of Kantian ethics. Yeah, you learn a lot with me. Sorry. Anyway, the point is, you want to do kind of the same thing here with the rules. And what do I mean by that? I mean, just like we did throughout this whole video, taking particular claims that were made throughout the objection and thinking, well, is that always true? If we were to take that line of reasoning, the line of reasoning, for instance, that we don't have to, or that it's even possible to offer a statement without showing its content. Then we think, okay, is that true? Can that be universally applied? Well, if you're offering a statement without showing its content, then why will you use it at all? So why would the point of the rule be to forbid the using of content? If the rule also allowed for exceptions, if the rule also allowed for within its own definition other uses of statements that aren't for the truth of the matter. So the rule isn't preventing the content of out-of-court statements. It's preventing truth value. Truth value of what? Asserted in that statement. In the statement itself. So the characterization of an out-of-court statement does need the out-of-court statement's content. But whether or not whatever is asserted in that content is true, we're not going to prove that. And we're not offering the statement to prove it. When we say in court, Jabari and X were discussing ice cream, we're not using it to show that Jabari likes ice cream, essentially. Why? Because that's the truth of the matter of the out-of-court statement, and we're not offering the out-of-court statement for that. We're not even offering an out-of-court statement per se. We're characterizing an out-of-court statement using its content without any regard to its truth value. We have to articulate these things clearly once we think them through. Okay? And I try to make this clear in the final ruling.
If I may respond?
Please.
I'd like to take you back to the question that was at stake here. That was the context of this phone call. If it was between Ms. Kosak's assistant and this witness.
Right.
Opposing counsel testified, opposing counsel stated, if I can ask opposing counsel to restate his objection basis.
Okay.
Sure. The crux of it is that it doesn't really matter what the witness did or didn't do next. And if that's the information counsel's interested in, she can ask him that without putting on the record all of the information about what she thinks or what he thinks the phone call was specifically about. Unless there's some hearsay exception that applies, which would let that content in. Otherwise, there's no exception that lets us talk about the content of that call.
Your Honor, this question was merely foundational. It was going to, that a conversation took place in the first place, which is sufficient to go to the subsequent action, which later in testimony will be shown.
I think the meat of it is, coming back to the meat of it, the meat of it is you're characterizing a conversation.
You got close there. You got close there when you said it was foundational to show that the conversation took place. Right. So you want the conversation to take place, and you want to. But the problem is, again, you're still not getting there. You're not there. The question is, remember the question, is the characterization of the out-of-court statement hearsay. In other words, it's not just that you want the jury to understand that a conversation took place, because then you wouldn't be offering the statement at all. The only thing you would need to ask the witness was, did you talk to this person named Kennedy? You want the content of those statements in, right? And you want to use it for a particular purpose. You have to make clear. It's all about clarity. You have to make clear that you want the content, but you just don't want it for its truth value. You want a characterization of the out-of-court statement. But that characterization of the out-of-court statement, while you want that particular characterization to be true, you don't need to rely on the truth value, if there was any at all, of the out-of-court statements that you used to deduce the topic of that conversation. Right? I know it's a lot, but here's the kind of final ruling.
And you have to rely on the out-of-court conversation. Right. Not on the content, on what was said. And you
see, like I said in the video here, you have to rely on the out-of-court content to be able to characterize the conversation.
Relying on the truth value of those statements, right? To be able to characterize it and to get him to characterize it as being about safety.
It's going to the subsequent action, not the necessary truth value that was
Okay.
of the statements.
This is what I wanted to rule. The truth value of the statements isn't necessarily the same thing as the content.
See, content isn't the same as truth value.
He can characterize what the conversation is about. But that doesn't go to whether or not the specific claims, if you're going to elicit any at all, in the conversation were true.
Yes, Your Honor.
Therefore, you're not using them for the truth value. You're using them to explain what happened next, which is supposed to be some sort of record of what he did or what he wrote or something like that?
Yes, Your Honor.
Okay, so I'm going to allow the characterization of the conversation because they're not going, she's not using it for the truth of the matter. She's using these statements to just provide, as you said, context, and that isn't the truth of the matter. It's not going to prove that what was said out of court was true, but rather just what was said.
Right. It's not going to show the truth of the matter asserted during the out-of-court conversation. Rather, the out-of-court conversation is the basis of the characterization. And that characterization can be made regardless of whether or not the statements made during that out-of-court conversation are true. I hope that's clear. It's a long video, so kind of digest it as you will. I did my best. Let me know if you have any questions. Maybe watch 15 minutes at a time or something.
Yes, sir.
I'm so sorry. But, yeah. I'll see you later. Bye.